Yes, I think we are.
Please go ahead. Please go ahead. We are live now.
So, Mr. James, we can start with your opening remarks.
Amreen,
Live now. Yeah.
is there any other opening observation?
No, sir. You may please start. Thank you.
Okay. Thank you. Mr. A.K. Mittal, Advisor, Network Systems and Network Technologies, Telecommunication Standard Development Society of India. Dr. Yashwant Dev Patla, Scientist E and Head, Patent Facilitation Center, TIFAC. Mr. Dirk Willer of Standards Policy, Nokia. Mr. Patrick Hopkins, Director, Ipr Policy, Ericsson, and dear participants. On behalf of NIPPO and ASSOCHAM, I finally welcome you all to this NIPPO ASSOCHAM joint webinar on global developments in SEP and FRAND licensing. NIPPO has been following the jurisprudential developments and policy and regulatory issues related to standard essential patents and their licensing under reasonable and non-discriminatory terms quite keenly. They have also been a subject of debate in the global IP market in recent years. The courts and regulatory authorities taking a much closer look at the issues surrounding them and other developments also having a major impact. The matter is of great significance to India. Second largest telecommunications network in the world. Currently, policies and jurisprudence in India on issues related to standard setting organizations, intellectual property policies, and FRAND licensing disputes are in formation, I would say that way. And issues involved at the core of all these matters are currently being debated on a global scale. How India chooses to shape its policies related to IP enforcement and FRAND licensing issues will be interesting to international dialogue. But more importantly, it would be instrumental in determining the India's future in the world wireless and value chain. With the government's initiatives on Make in India, Design India, and Atmanirbhar or self-reliant India with global reach, it is imperative that the adopted IPR policies are attractive both to implementers and inventors of new technologies, so that local investment in R&D and manufacturing is lucrative, as well as for activities to climb further in the value chain towards long-term innovation. Thus, we believe that it is crucial to equip all stakeholders with the latest global developments in SEP and FRAND licensing. In furtherance of this goal, we are delighted to partner with ASSOCHAM in creating awareness about this very important subject. By way of introduction, let me say a few words about NIPPO. NIPPO is the first and oldest techno-legal NGO in India dedicated to mobilizing the use of intellectual property for economic and social development by creating an IP culture and enhancing knowledge and competencies in tune with the global environment. It is an association of creators, users, and owners of intellectual property and works for advancing an intellectual property agenda that promotes business practices, commercial infrastructure, innovation, and law. It aims at fostering economic growth through efficient development, use, and exchange of IP rights at the point where technology advancement, IP rights, and job creation all intersect. It is one of the few non-governmental organizations world over to have been granted permanent observer status by World Intellectual Property Organization of the United Nations. Members of NIPO include, as I already mentioned, scientists, authors, artists, filmmakers, musicians, corporates, civil servants, academicians, legal experts, and other intellectuals. It provides all stakeholders with a strong voice on IP matters affecting their future business through regular publications, awareness campaigns, capacity building programs, and conferences to both educate and engage the public in debate on topics like IP management, IP enforcement, litigation, alternative dispute resolution, and related issues. Our most recent collaboration has been with WIPO Arbitration and Mediation Center, Singapore, wherein we successfully organized a joint webinar on the topic WIPO ADR mechanism as a way forward for IP and technology conflict resolution in India. Today, we have a group of experts on the topic of FRAND licensing as well as industry practitioners. I heartily welcome Mr. A.K. Mittal, Advisor, Telecommunication Standards Development Society, India, as guest of honor. My friend, Dr. Yashwandev Panwar, Scientist and Head Patent Facilitation Center, TIFAC, Mr. Dirk Willer, Head of Standards Policy, Nokia, and Mr. Patrick Hopkins, Director, IPR Policy, Ericsson, who are all persons of eminence and well qualified to talk about current domestic and global developments on this important issue, which affect greatly the future of electronic and communication technologies. It would be really enriching to hear them. Let me also inform you that we will be having two wonderful rapporteurs on behalf of NIPO who will be putting the speaker's thoughts into paper so that it can be submitted as a general report to the Government of India on behalf of our organizations. I wish you all a very exciting session. Thank you and welcome all of you.
Once again, good afternoon, and thank you very much, Professor James, for enlightening words. It's not a start, but I think you have given the complete background for the purpose which this seminar is being organized, and discussions have been coordinated by NIPO and ASSOCHAM. So I also thank ASSOCHAM and NIPO for providing the opportunity to really share my mind with the experts like Dr. Mittal, Dr. Dirk, and Dr. Patrick to discuss a subject which is very dear to my heart, and also I have done some research in this area as part of my doctoral work. So I'm very happy to interact and present myself before you. So let me first introduce the TIFAC. TIFAC is a Technology Information Forecasting and Assessment Council, which looks at technology vision or do vision exercise for future. And then these standards and patents and innovations and technology is our life day-to-day ingredient of surviving and working for the future of the country and the future of the humanity with the assistance of technology. So I would like to introduce my co-panelist for this workshop or webinar on SEP and FRANDs. First, I would like to introduce Mr. A.K. Mittal, the guest of honor, I would like to read the bios, the very brief bios. Dr. Mittal did his graduation in Electronics and Communication Engineering from IIT Roorkee, and he has, to his credit, Management Diploma from Institute of Repute, and the experience, phenomenal experience of 40 years in the area of telecommunication. So I think he understands issues of standards, patents, which are at the forefront of discussion of the country's development when we are ushering into the frontiers in information technology, where we talk about IoT, we talk about artificial intelligence, and we talk about 5G and the next generation of communication standards, which we are working on. And I think he is having adequate experience and a right person to really help us in formalizing some recommendations or some takeaway from this webinar. So, and then we have with us the second speaker as Dirk Willer. He is at the center of a policy at Nokia Bell Labs and has been handling standard portfolio. He worked with standard setting organizations, remained chairman of ETSI board since 2014. So I think this Europe has taken a lot of lead in the standard setting, standard development, and handling issues relating to SEPs all around the globe. And I think I'm very excited to read one line from his bio that he was instrumental in creating TSDSI from Dr. Mittal is coming from. And then I would like to, on a lighter note, I would like to say when we talk about standards in India and the Nokia, we used to have that charger. So it's very common in Indian public, and even has been quoted in movies that patli pin ka chargers, so the thin pin charger. So those are the standards from Nokia, which are known in this country at a mass level, but at the technologist level, definitely we understand the importance of standards, patents, and standard essential patents, and how do we share those innovation with the implementers. We also have with us Mr. Patrick. He is a director of IPR policy at Ericsson as a Brussels office, and he also has phenomenal experience of handling issues relating to licensing of these SEPs. He has, I think, dealt FRAND and RAND at different levels, and help in building policies for standard setting organizations. He has been a key person who handle technologies, machine-to-machine communication, different wireless solutions for IoT, etc., etc. And he holds a degree of law from University of Leuven, and also his master in company law from University of Brussels. So if I see, we have two technologists with us, Dr. Mittal and Dr. Dirk, as a technology degrees, but the experience in these issues. And Patrick, I think, holds a law degree. So we have a combination of technology and law, which is required to take forward innovation, because when we talk about intellectual property rights, this is essential to understand techno-legal issues. So now, when we talk about standard essential patents, so if this is not in a specific species or a separate species from the patent, these are patents as a normal patent. But when you set up the technology standards and the interoperability of different devices or intercommunication of maybe network devices, individual mobile devices, then those bundle of technology becomes very important. And if those are made standards and those become as standards, so standard setting processes are different. There may be cooperative standards, there may be regulatory standards. But at the moment, we are focusing on standards related to information and communication technologies. But if we look at India, about more than 50 plus standard setting organization, standard related organization, which sets the standards, which monitors the standards in different technology areas. So it may not be a very good idea to focus only these issues of standard essential patents with relating to ICT. Those are also in other areas of technology, even in agriculture related issues. Those complication has emerged in this country, where essentiality of patents relating to some of the products have been witnessed, and we went into litigation. But today's discussion is really focused with regard to ICT technology and standard related issues. And a lot of cases have happened around the globe and also within this country. A lot of judgments from different courts. A lot of policies are in place at a different standard setting organization level. The government policies, then different guidelines by patent offices. We are talking about JPO guidelines. We are talking about GONGDO guidelines, which are handling and helping implementers and innovators to come on table and discuss the ways and means to take implementation of technology and availability of this technology to a large scale, mass scale. So the few fundamental questions. So how I would like to structure this discussion, I would take few questions and will request our panelists to throw light on those issues relating to those questions. So, see, we all understand, but still we want to have specific views from our experts. So first I would like to invite Dr. Dirk to throw some light on significance of standardization and the standard essential patents. So Mr. Dirk, please.
Good afternoon, and thank you very much for inviting me to this webinar. I should add that I'm speaking in my own capacity, not here now representing Nokia or ETSI, where I'm the chairman of the board, but I also have been chairing ETSI's IPR committee for the last for 10 years. And I think the first time I was in India was in 2011 on a workshop organized by ITU on the standards and patents. And if I may invite to mute yourself, because this is quite some background, I think, that is appreciated by the audience. Thank you. When you ask what is the significance of standardization and what's a SEP, and I think in the industry we are talking here about, information and communication technology, and specifically the communication technology, this industry is based on standards. Without standards, we wouldn't have a global system for mobile communication, which is now LTE with and 5G with now I think some 7 billion devices connected and people connected all over the globe. And the only reason that this can work is the existence of standards through the whole communication network and services, so that everybody can interwork every device from whatever manufacturer, from whatever operator you are using, which services you are using. The only reason that this works is that we have global standards which are applied globally, and this is creating this whole ecosystem. And we need to keep that in mind, that these standards have a very pro-competitive effect. They are also voluntary. So the participants to the standard setting organizations, like ETSI, like TSDSI, they contribute their best technology into these standards and willingly do so. And rather than trying to build a monopoly and create technology just for their own use and exclude others. Of course, when they create standards and by contributing their technology, it is of utmost importance that this technology is available for everybody to implement these standards and this technology. And therefore, standards organizations like ETSI, like TSDSI have, and of course many others have created IPR policies which define the conditions under which the technology can be used, and rather than defining any specific license, any specific economic terms for that, they require, when this technology is accepted and is in the standard, that the patent owner gives a FRAND license, that the patent owner commits to offer licenses on FRAND terms, on fair, reasonable, and non-discriminatory terms, and so that everybody can implement the standards. So the standards are available to all. And the standards organization, by creating this patent policy, and by the way, the TSDSI patent policy has been based on ETSI's IPR policy. And when you read both, you will see how much similar they are, and they stay. And also other standards organization like ISO or IEC and BIS in India, they use the same principle of FRAND. So, and what is then a standards essential patent? Well, this is not a defined term, a generally defined term. We have to acknowledge that. It might, in the sense, or it means in the sense of ETSI or TSDSI, that this standard cannot be implemented without infringing that patent. But it is meant on a technical essential basis. So it is not meant on a commercially essential basis. You have maybe patents which you would need to infringe by implementing a standard which is not technically reading on the standard, which is needed to bring your product on the market. They are not covered by this policy. And of course, there is also not guarantee that everything which is called a SEP is really standard essential, because what you do is you require the contributors of technology to give in a relatively early stage a declaration that you believe your patent is essential to the standard, if that standard is implemented as envisaged, so that you cannot circumvent that. But when you give that in an early stage of the standard development, you might not be sure that it is really essential. So they are declared essential. And this is not because companies want to have as many patents in that standard declared as possible, but it is to give an assurance for everybody implementing the standard. Well, if I need that standard, I can have access to it. If I need that patent, I can implement the standard, and if needed, I can a license will be available so that you can everybody can implement the standard. And this is I think this is and you said it already, that the SEP is a patent. It is nothing more, it is nothing less, with all the rights of a patent. And because I have to say this, because in my many interactions with all kinds of users, you often hear, well, this is now a standard essential patent, this is something special, so we need to define what are the rights for you. But on the contrary, it's a patent, and the patent law gives you the rights for you for the standard essential patent as for any other patent. Thank you.
Thank you, Dirk. Thank you, Dirk, for enlightening us on this very basics of SEP. But see, if we look at different court cases, judgments, and all, so we may define the SEP in certain manner, but if we look at some of the decisions, this is, if there is optional technologies available, still it is called a standard essential patent. So all those things are there. So I think I will not dwell on this issue when Patrick is there as a legal expert. I would like him to clarify on, see, as there is no standard definition, but somewhere and somehow we have to come on a common platform and to have an understanding amongst our audience who are listening to us, the boundaries of potential area of standard essential patent. So Patrick, can you just throw your views on how do we define SEP and what acceptable terms?
I will definitely, I would want to come back very quickly to the significance of standardization first, if that's okay with you, and then move to the topic. Please. So, because I think there are two elements that I would like to add to what Dirk was saying on a more holistic level, more on a general level. Because the significance of standardization is not only for those who create the standard, of course. There is also a huge significance for those who can use the standard, and for consumers. Let's not forget consumers. And the best way to describe that significance is by a very concrete example. If we look at mobile telephony, if we look at I've been asked here to turn off the virtual background. So voila, this is I'm working from home, as you can see. So, but if we look at telephony, if we look at mobile standards, before standardization started in this massive way, so GSM 2G, which was the late 80s, mid 80s to late 80s, we had already mobile telephony. You had a very big brick that everybody may remember from Motorola, a big telephone. That device costed $4,000. And it would operate in Europe. It would operate not even in entire countries. It would operate in a country, perhaps, or it would operate in a part of a country. If you take the things to the US, you could not operate everywhere. And the reason was we had all these different standards of mobile telephony, one juxtaposed to another. And so gradually what happened, as Dirk said, is that you created a global ecosystem. And in that global ecosystem, it was about, of course, interoperability, creating more and more interoperability. But what that global ecosystem did was reduce prices for consumers, whilst at the same time improving performance. So again, going back to that big telephone of the beginning, $4,000, it could not do data. If you look today, we have very small, very cheap mobile phones who can do a myriad of different applications because they are able to process data in a very efficient manner. So standards help reducing price while increasing performance for consumers. For people that are new to standards, companies that are new to standards, they provide an ecosystem in which they can really innovate. So somebody who has never done anything in standardization can, from day one, actually start standing on the shoulders of the standards, using that technology to make new products. And my background, I come myself from a company that actually found between two standards, IT standards and telecom standards, a gap in the market. And we created products that really complied these two standards and integrated them together. And so from an SME of 20 people, we grew that company to 800 people by really using the standardization framework, because it gives you technology that you can use to make new products, and it gives you access to a global market. So I think that there are two very important elements for standardization. And so apart from the elements that Dirk said. Now, turning to SEPs, the reason that there is not really one definition of SEPs is that SEPs, you will not find them in patent law, for instance, because SEPs are fundamentally, as Dirk said, patents. And they are patents with a contractual layer on top of it. So a contractual layer that is made by those who have the patent and make a commitment with the standardization organization. In the case, for instance, of TSDSI, when you have contributed technology and you're willing to make a FRAND commitment, what you actually do is you enter into a contract with TSDSI, and that contract is to the benefit of somebody who wants to use the technology. And so that's why it's very difficult to have a unique, if you want, standard essential patent definition, because as you mentioned before already yourself, there are so many standard development organizations that have all different activities, have very different constitutions very often. TSDSI, ETSI are standardizations that are set up in a certain way. In ETSI, we have members that are companies, but we have also national delegations that are also present, and so you have a mixed membership. If you go to IEEE, it's more individual people that are represented. If you go to ITU, it's all national companies and national countries, and companies there have a very different role to play. So the membership is different in SDOs, and last but not least, the IPR policies of SDOs are very different. The IPR policies, basically what they tend to do, I think, is two things. First of all, they try to help make sure that when the standard is created, that it can be disseminated, that it can be used, the standard, technology that is standardized. And secondly, it is a sort of reflection of the business model of the standardization body, if that exists. I explain myself why. There are some standardization bodies that are selling their standards. It's not the case of ETSI, but there are some standardization bodies that are just selling standards. There are standardization bodies that have a FRAND commitment. There are standardization bodies that require royalty-free. So you have different business models, and they are expressed via the IPR policy. So if you then want to go and say, let's define in law what a standard essential patent is, you are confronted with a number of questions. The first question is, who defines what a standard is? Is it de facto standards or is it the Euro standards? So when will that definition kick in? That's the first question you have to ask. Second question, if you have a definition in patent law, what do you do with the voluntary nature of standardization? Because today you can decide whether or not you want to contribute your technology to a standard. But if you would have a definition by law, the moment that you have a patent that actually reads on a standard, it is a standard essential patent, whether or not you're willing to contribute it. And that is potentially problematic, because ETSI for the moment has the possibility of refusing that. And then ETSI will have to do a workaround and not using that technology, because a standard that would have a technology for which the patent owner is not willing to grant a license is problematic, of course. And so defining SEPs in patent law is not that easy. It may seem on prima facie like a good idea, but I think if you look at the practicalities and the questions that are raised with it, I think it's actually not possible. And given the different tasks, different activities of the standardization bodies, I think it's much better to have a flexible system whereby you have, different elements of the law that are relevant. Competition law is relevant, patent law is relevant, but also contract law is relevant. They all have a role to play in this ecosystem.
Thank you. You have tried to cover the requirement of bringing this particular species of patents, which we are trying to call it standard essential patent, into patent law or a patent statute. And it has not been there around the globe in any of the patent statutes. You rightly pointed out that there are alternatives available to handle these issues. So it may not be necessary to bring into patents and make things complicated or disturb the ecosystem, which is functioning very well, which we call a patent protection system. So we have this issue. We have to find out other ways and means to handle in more efficient manner than we are doing at this moment. But see, when we look at essentiality of patents in those particular standards, the different views emerges, different court cases came in, and whether it's a 1 patent or a 10 patents or a bouquet of patents which are being used in those standards. And we may talk about this fair, reasonable, and non-discriminatory, but on ground, when we go and implement, in reality, it may not be non-discriminatory because there's some confidential agreement, and confidentially these things are handled. So how do you know that those are non-discriminatory or not? When we talk about IPR policies of different standard setting organizations, you have different policies, and on different terms, you make your technologies part of those standards. So in some cases, if we read, a few people say, where there is a reciprocity is there, or the other parties are also part of those standards, then only they will share the technology with them on FRAND terms. There are some unconditional declaration that we will share technology with all. So there are different models available. So how do we bring in harmony amongst all these different models and make life easier for implementers? Or can we have some common platform where we can have one-stop shop or a single window facility where we can access these standards and get license to these patents? So those are little far possibilities, but still we can orient our mind towards creating those kind of framework, setup, and systems. But let's discuss the setup which is available to us at this moment of time. So on essentiality aspect, Patrick, I think we wanted some more clarity from you. When we call and how do we define, we say this is a standard essential patent in light of different judgments around the globe and different definitions given. So do you want to add something on?
So I think on the definition of standardization patent, I just covered that by referring to the non-one size fits all, the contractual thing. One element that I would like to pick on that you said, the harmonization, the common platform. I think, and we'll talk about that later, we have had very vibrant and very interesting discussions over the last couple of years in relation to FRAND and discussions at many levels, in the IPR policy groups where I humbly served under the chairmanship of Dirk Willer for a long time. We had a lot of discussions. There are also in some court cases very interesting discussions. And what we see happening today, I think, is that there are, especially now I'm talking from Europe, which I know best as I'm resident of Europe. What you see is that after years and years of discussions, some very high courts, thinking of the Supreme Court in UK, thinking of the Federal Court in Germany, have come out with some decisions. There's also the CGU in Huawei ZTE in a case from 2015. So you have really courts that are providing clearer guidance, that are providing certain elements that you need to take into account when you enter into license negotiations. And so that provides clarity, that provides for some more harmonization. There has also been initiatives of the industry in terms of pooling, when you refer to that. I'm thinking of the Avanci pool. So in IoT, the big challenge is, companies that are not really familiar with the whole telecom licensing, how will they be able to know what they need to do? Well, the Avanci pool is a pool that has now 38, I think, licensors together. 14 different car makers have taken a license from the Avanci pool. So that is also something that you will see happening, I think, in IoT.
Yeah. So when you talk about cars and all, then again, those issues will come up of equipment value or which is added to the final products. I think Dirk has already commented on this, but if we look at, you talk about European situation, the court decisions, at some point of time I read that only about 16% patents which were declared, which were really standard essential patents out of all declared standard essential patents. So different numbers coming from different places, 16%, 22%, and all. So Dirk, can you comment on that, how these things are really defining essentiality in standard essential patents?
Well, what I have said is already that when we look at declared essential patents,
yes, you already made it clear, but I just wanted to have more clarity for the audience understanding.
Yes, of course. So we need clearly to distinguish between also the reasons why companies are, so members of standards organizations are pushed to declare patents. And this is to give the assurance to implementers that if they need access to the patent, it will be there. Therefore, standards organizations like ETSI, or I think also TSDSI, ask for declaring early potentially essential patents to that standards. And this will make sure that the standardization development and afterwards the standardization implementation is not hindered, and they don't need to care about whether there might be patents which are not available. And so this is also why the industry is talking here about not the single patent, but to have a portfolio license and portfolio of patents. And when you try now to challenge each and every patent, maybe even in each and every jurisdiction of such a portfolio, for sure you will find patents which are invalid, which are not infringed, which are not sorry. So there is this is a much bigger number of patents which are declared than those where, when you then later in that chain, the patent owner will now offer licenses to the implementers. then they will, of course, include all in such a portfolio license offer, all the declared patents, but makes clear here is they will show their patents which they firmly believe they are standards essential, and so the discrepancy between declared patents and those these numbers are very obvious, and the reason for that is clearly very obvious.
Yeah, it may be a little unscheduled issue, but I would like to bring in one point here. See, by very nature, patent is a territorial right. So when you declare like European patent as a part of a standard, and that is a standard essential patent, but if that has not been protected or does not have extended family, it has not been filed in India, it has not been protected in many countries. So it may not remain a patent at all. So still, when you have a bouquet licensing or a portfolio licensing, so the portfolio will change its shape and size in different countries differently. So there has to be an understanding at that level when this territoriality of patent rights also taken into account while doing the business in different countries. I think.
Yes.
Would you like to say something?
Yes, absolutely. I mean, you have what we started with is that we have globally applicable standards which create a global business, and the business we are talking about is global. I think there is no doubt about that.
Yes.
So you have an
business is global, but patents are territorial.
Yes, absolutely.
So
absolutely.
That's where we yeah.
Yes, but I think what has to be understood is the nature of a portfolio license on a global basis. The reason for doing that is that as the business is global, and most of the implementers in that ecosystem want to sell their products on a global basis, on a global level. So they, by offering and taking then a patent portfolio, a global patent portfolio license, that means there is no relevance whether now a single patent is valid or not, whether there is even a patent issued in a certain jurisdiction, in a certain country or not. You offer this portfolio, and there is, you could clearly say there is a huge discount on the individual patent when you offer a global portfolio license. And here comes the challenge which the patent owners and the licensors are faced with, is that yes, in that portfolio it's not valid in every jurisdiction, in each and every patent. That's the assumption, and everybody knows this. But with this huge discount overall, this means that when you, as an implementer, you start now to say, well, I think there are invalid patents in there, and you can even go that far. Let me give that example. You can ask your CFO in the company before starting to negotiate a license. Look, my dear Chief Financial Officer, I have two choices. We're operating in a business where there is a clear, broad acceptance of portfolio licensing on a global level, and we have many companies still who simply agree on negotiated licenses in this business. And so now my CFO, I have two options. I can take now, today, a portfolio license. We can discuss a bit the price, yes, but it has to be FRAND. And I can now agree on taking such a portfolio license. And if you are a very, very big company making hundreds of billion turnover and with the sale of your product, you might pay some billions of licensing fees for that. But CFO, I have an alternative. What I can do is instead, I can start now to challenge each and every patent in each and every jurisdiction and delay forever to take such a portfolio license. And therefore, but what are the costs for that compared? Well, it's maybe a couple, two-digit millions, which I have to pay for lawyers' cost. And what the worst thing what can happen is that at the end, somebody like Judge Berth in the UK will decide, well, you either take a global portfolio license or you will be injuncted here. And so, but the price, we're still talking about the FRAND rate. So that rate, what this implementer will pay is at maximum that FRAND rate, regardless how long it has negotiated and challenged and adjudicated in each and every country. And so this system is giving a benefit for those who are not willingly take a license early, but delay taking that license for many years. And this is why we see quite some problems with the situation of holdout.
So thank you. But thank you very much for a clarification. And I would like to draw some analogy from general terms for the benefit of audience who are listening to this. See, when you enter into a hotel and check in a room, then you take a license to use all facilities, gym, swimming pool, or kitchen, and you cannot go and complain that I don't pay for restaurant facility I have not used, the gym I have not used, or that I have not used. So there has to be a model when you deal number of facilities or together. So here you are dealing with number of technologies together you are trying to access. And then when we talk about these products, these products are not protected by one patent or two patents. So these ICT products are actually utilizing few thousands of patents, and many of them are essential when you try to make these products, be it the mobile phone, be it the component of a mobile phone, or be it the devices which are used in a network, maybe tower, or you can think about any device. So there's a huge volume. So when you deal volume, then I think I agree that there has to be some model like the portfolio licensing. So you cannot go and differentiating and fighting on small issues. So another question the host wanted that we should look into it. So the holdouts, which delays, and I think Dr. Dirk started discussion on this. Now, I would like to request Patrick to enlighten us on views taken by judges in different territories and different part of the world on these holdout issues.
Yeah. So holdout has been more and more brought to the foreground. There was a time. Oh, I see myself now. Big. There was a time where the antitrust authorities in the world were much more focused on hold up, and we had a whole narrative on hold up. But what people started to realize was that after decades of discussion of hold up, that there was actually no proof of hold up, and the reason for that is relatively simple, I think. We'll come to that, I guess, in a minute, but the access to injunctions is more limited in the case of standard essential patents. One. Two, there is a FRAND commitment. And so hold up with a FRAND commitment seems like very strange as a combination. So what has happened is that people started to realize that, and at the same time started to see that more and more companies that held patents had problems enforcing these patents. Typical time for negotiations took longer and longer and longer. Negotiations dragged on for years and years. And so there are more and more court cases where that has really come out and where judges have looked into that behavior and has qualified sometimes that behavior as holdout. And the first decision that comes to mind is the Unwired Planet decision in England, which is a decision that has gathered a lot of attention and is gone all the way up to the Supreme Court in the UK. And in that decision, in the first decision of Unwired Planet, Judge Burse, who did an incredible job in a very long and much talked about decision, he really looked at the behavior of the parties and he analyzed some of the witness statements and came to the conclusion that he says there is clear potential for holdouts and to occur on theoretical grounds. And then when I listen to the parties and when I listen to the witness statement, it's clear that people, what implementers have tried to do is limit the discussions to the technical level. No, they never go to the commercial discussion. So drag on the technical discussions forever, and by doing that, avoiding to have to take a license or to come to the discussion on the license. That's clear behavior of holdout. Equally, in the UK, there is the decision on TQ Delta versus Zixel, where the same conclusion was made that basically what Zixel tried to do was drag the technical discussion so long that you couldn't come to a commercial discussion. As we all know, a patent's lifetime is limited. And so the longer you drag on these technical discussions, the shorter the lifetime of the patent becomes. But it's not only in the UK, also in the Netherlands, there is a case involving Phillips and Azustek, so where the court also saw behavior that they qualified as holdouts. And concretely, it was negotiations where the implementer would not take qualified technical people to the meetings. So you had technical discussions without technical people in the room. So needless to say that these discussions were very short. And every time again, when Philips tried to have the commercial discussions, they would interject technical questions without the presence of technical people. So different courts, also the German courts recently in the cases that involve Daimler, has clearly said that there is behavior that is indicative of holdout behavior, where not willing to negotiate, not willing to engage into technical or into commercial discussions, etc. All that's to say that both the European Commission and also I think at the other side of the pond, the US USPTO, the DOJ, have recognized that there needs to be attention to holdout, and that holdout does exist, and so it is something that has been recognized in facts, that is evidenced by courts, and that requires attention from the regulator. How can we get a balanced system so that parties are incentivized to negotiate in good faith is really the question that is central in the approach of regulators to this matter.
Thank you so much. Thank you so much for clarifying the points on this particular issue of holdouts. And Dr. Dirk started between the discussion about injunctive relief to the patent holder in case of standard essential patents. And there's a business review letter by US Department of Justice. So I think I would request both the panelists to share their views on this. Yeah, so Dirk can.
Okay, I can start. Yes, or
okay.
you Patrick, you
I can start. Yes. So the business review letter is one. So the amended business review letter. I think we all know that there has been a business review letter, leading to the change of IEEE's policy back in 2015. then something happened very recently, which is, I think it's unprecedented, but I'm not a US lawyer, so I'm not qualified to say whether it's unprecedented or not, but I think it's unprecedented, that Business Review Letter of 2015 was amended by a new Business Review Letter that was that intervened recently. And the reason for that intervention are multiple reasons, but one of the elements was that the DOJ said that the way it was anticipated the facts and the law would evolve in the US was not entirely correct. And one element was injunctive relief, where what the DOJ has done now in this business review letter, but it had also done it in a joint statement that occurred end of last year. And that's actually very important to not forget. There is a joint statement end of last year by the DOJ, USPTO, and NIST that has the same sort of logic, and basically saying, if you need to have a balanced system whereby both parties are incentivized to negotiate, then you cannot eradicate the access to injunctive relief for the SEP owner. Because if you eradicate that totally, if you completely say that there is no access to injunctive relief, what you basically do is incentivize the implementer to hold out, to wait and to see, until a court will decide, and then we come to the thing that Dirk said. If the worst you can have is a FRAND conviction, then you may as well wait until you get there. So the injunctive relief is seen as an important element to have a dynamic of negotiation. And the DOJ is not alone in that, or USPTO and NIST. I think it very much resonates what's also happened in a bit earlier in Europe with the CGU decision in Huawei ZTE, where I think there is the same logic, where people say, injunctions are not off the table. They are on the table under certain conditions. If, as a patent owner, you make information available, you make a FRAND offer, and then you see that the implementer is really unwilling to engage into discussing that FRAND offer, then injunctions are back on the table. And the reason being then that is a way to incentivize people, implementers, to come to the table and to negotiate. And the CGU has approached this in a very procedural manner. First the patent holder does this, then the implementer has to do this, etc. But the basic mechanism behind this is the same as the DOJ, a concern for having a balanced system where the FRAND negotiation is a two-way street, where both parties engage in good faith negotiations to try to come to a resolution, and as you said, on a situation of thousands and thousands of patents. Very briefly on your point of geographical questions, that is being recognized in the UK Supreme Court and in the German Federal Court, so the highest courts, that indeed, it's a portfolio given in a global environment. Industry practice moves to that. But there can, of course, be exceptions where a company only is active in one single country, in which case you need to be looking at that situation in particular. But most of the time, it's really a global market with global companies acting, in different parts of the world. And so if you take off injunctions off the table totally, what you would get is the necessity to go after infringement on a country by country by country by country basis, and that doesn't seem like a really workable solution.
Yeah, thank you so much. Thank you so much. Actually, this again cements the point which Dirk and we discussed earlier, that the SEP is not a special category; it's a patent, nothing more and nothing less. So the injunctive relief is an integral part of that particular system and thought process. So yeah, Dirk, please.
Yeah, I think Patrick has very well already described. I want to emphasize this need and the recognized need for having access to injunctions with the right remedies, of course, but to this business review letter of the U.S. Department of Justice was really remarkable in many ways. Also, that how the IEEE and companies there who were benefiting from this new policy were arguing that the DOJ had given support for the changed policy itself, rather than just saying we could not see that how the policy has been developed was wrong. And I think this is another remarkable element of that. But I think what has been now more and could now be seen more and more is that there is an acceptance that when you want negotiated licenses, there needs to be checks and balances for both sides. And just putting this obligation unilaterally on the patent owner and giving the implementer the choice, whatever he does, it has no consequences. This has been rectified and said, you have an obligation. If you want to benefit from this FRAND contract between the standards organization and the patent owner, you have to behave properly. And if you do not do that, then you cannot benefit from that. And I think this is, whether it is, as said, the Federal Court of Justice, whether the Court of Justice of the European Union, there is a large acceptance that it matters how both parties act, and this has to be seen in each individual case.
Thank you. I think while answering this particular question, you have actually prompted us to take up the next question. See, the dispute will always be there. So if you are selling something and if you're buying something, and if you're not agreeing on terms and condition, or whether it's a rate or any other terms and condition, if you're not agreeing, disputes are bound to happen. But those disputes goes to court and judiciary when you cross the limit. Either party or either side cross the limit or the cross the boundary. Then those things land into the court or a judicial system for amicable or settlement of those disputes. But now, all the question always take a forefront at what level or at what stage of a value chain these licensing should be done or can be done in this whole technology chain. See, we talk about components, we talk about devices, and we have users at end. So that has not been discussed in any form. I have not seen that we have gone in value chain that far at a user level, because see, the infringement of patent, if we read a very definition of patents, making, using. So the using patents, so it may not be for making, but if I bought an instrument which is infringing some patents, I also can be sued for infringement of patent. But the patent holder or SEP holders will not sue me as an individual because they will not see benefit in me. And there's a component manufacturers. So these SEP holders are not going behind the component manufacturers because they don't see much value in enforcing patents there. So everything is related of seeking royalty from value enhancement of those products, and those products are devices. So at a device level, SEP holder want to enforce the patent rights and negotiate licenses. So I think I want your wild views on this particular issue, where it should be in a value chain, and what are alternative opportunities or options to discuss these licenses at a different level of value chain. Patrick.
Yes. Okay, I would like to start on that. I think we first can simply go back again to the fact SEPs are normal patents, and it is up to the patentee to define a strategy how you want to license your patents. You cannot claim from the user of the patent, I tell you how you have to license. First, it is up to the patentee. And we have seen in mobile communication, it is clear there is the established practice that the licenses will be given to the device and not to the chipset level. And the courts at large have not decided differently, but are accepting that. Now we are faced, of course, with other types of businesses, and one prominent one which is already ongoing for a couple of years is the automotive business, and there this business says, well, we have another way how to make business, because in automotive the OEMs say, well, we don't care of licenses, that has to be done by our suppliers, so I'm not interested in taking a license, and instead go to my suppliers, and they will have to manage that. And how now you have two different business models which are clashing. So who is right? Well, there is this fight, we know it, but we also know that many OEMs have already accepted to take, as Patrick has said, licenses from Avanci, from that pool. And we know from court cases that some other OEMs have not done it and want to push it to the limits to say you have to follow my model. And in this situation, of course, the courts would have to decide who is right, who is wrong. And what we can see in these cases of Daimler against Nokia, Nokia Daimler, so that we could see the court decisions to, well, first of all, tell the OEM, you are not willing to take a license. You have not shown the willingness to take a license. But on a broader sense, then there is the acknowledgement that the value, if we ask what is the appropriate value, what is the basis for calculating a license, and while you can say, well, we do different models in who is taking a license, but I think it is clear that the license should depend on what is the technical benefit of these innovations. And this technical benefit is not only in some part of a chip. The technical benefit for using the innovation, for implementing, using the standard, is on the device level, also there, not on the only on the chipset level, and therefore the appropriate level is the basis.
Yeah, I agree with you, because see, in this if we say, see, in this case, when we talk about automobiles, see, all your consumer goods or communication devices become a producer's goods in that. So that's the role change of that particular product from consumer good to a producer's good, and which fits into larger systems again. So then again, we seek the total value enhancement of those equipments. I think we are running behind the time. So Patrick, if you have a quick view on this, I'll move on to the next thing.
I'll be sorry, if I'll be very, very short. There are two big cases that have decided on the licensing level for the moment. That are really looked at that. Nokia Daimler and Sharp Daimler. There is one is Mannheim court in Germany, the other is Munich court, for both German courts. And basically they said, as Dirk said, patent owners are free to choose. Licensing at the final level, at the car level, is not discriminatory. Both courts come to that conclusion. What is specific in the Sharp case is that they also looked at the fact whether or not there is an obligation to license at all levels in the value chain. And they did that from the three elements that I discussed before: patent law, competition law, contract law. And from all these analyses, they said on none of these there is an obligation to license at all levels in the value chain. That's a Sharp decision. On the Nokia decision, there was a very interesting additional element, I think, that the court said, and Dirk hinted to it already, is that so the patent holder, the court said, must participate in the economic value of the technology for the sellable end product. And basically what they're saying is, if you use the TCU as the basis, it's not correct. Why is it not correct? Because the TCU is just a cost for Daimler, and it does not reflect the possibility for Daimler to make money with that technology. How can Daimler make money? By having a better service history for the car, by providing apps for the users, and to save R&D expenses themselves. And so the court says that needs to be taken into account, and therefore the TCU is just an element of cost. It's not sufficiently reflecting what Daimler can do with it. So I think that's important. Patent owners must be able to participate in the economic value of the technology.
Yeah. Thank you so much. I think the evolution of technology will actually decide the course of position of value chain in copyright licenses. If we see, we are now pay-per-use kind of licenses are given. So I think we may graduate in this area also, maybe after 5 years or 6 years later. We may have we have to graduate to that level in this area, but we are not near anyway. So we very quick comments with regard to JPO guidelines and the Hante system of essentiality check. So who would enter first?
I will be.
Yeah.
I will briefly start on the JPO guidelines. So the guidelines were interesting. It was basically doing a status of what the status of jurisprudence was at that moment in time. If you look at the guidelines, because in order to prepare for this webinar, I look back at the guidelines. The problem I see for the moment is that the last decision included in the guidelines dates from 2018, and then there are two decisions of 2017, one of which has been vacated, so it doesn't exist anymore. It's no precedent value. And so, cut a very long story short, the guidelines for the moment have not included in them yet the huge evolution that we have seen over the last 3-4 years with really high courts, high profile agencies chiming in on these topics. So I think
that's why we say these are very old guidelines.
Yeah, I also think if you want
call it very old, yeah.
If you want, well, 3-4 years is not, but also when you talk about guidelines and you do references to detailed court cases, of course you need to adapt them on a regular basis, and so that's not very easy. With regards to Hante, and I was remembered actually, I have to say I'm speaking, of course, on my own behalf, not on Ericsson's behalf. With regards to Hante, important to note, it exists since more than 2 years. From last checking, it had not been used. So there must be something that it does not appeal to the broader markets in the system. And I guess an individual patent on essentiality or not, the courts can decide on that. I think to what Dirk said earlier, we are more in a dynamic, in a logic of portfolios with hundreds and hundreds of patents. So the focus on an individual patent in terms of essentiality, well, it's always useful. There are certainly cases where it could be useful, but I guess the gist of the license negotiation that goes on is on a huge portfolio, and that may be one of the reasons why it's not that much used. But I have not studied the details of why people are not using it.
Yeah, but there may be a question of used portfolio. But if we look at litigation in India, it's actually few. Implementers are sued for few patents, 3 or 4 or 5 patents, and they've dragged into litigation. So there are different strategies. So we'll not go into that. I have a message from organizer We are running 5 minutes late, but Dirk, you can have very quick comment on this guidelines and the Hante system if you have additional to what Patrick said.
I think Patrick has said everything, so I have nothing to add for that.
Next week, the European Commission will issue, or 2 weeks, a very interesting report probably on essentiality checks. And that might be very interesting to have a further call or further discussion on that, because I guess they went into quite some details over the 2 years to see how complex it is, what is required to it. And that might be an interesting new document in that whole essentiality debate.
Thank you. So, see, my last question to be addressed are alternative dispute resolution. If we talk in India, we have a patent system, we have post-grant opposition system, we have intellectual property appellate board to handle the patents, we have a competition commission in place, we have arbitration in place, and then the whole judicial system is in place. So what alternative dispute resolution mechanism which you think is required amongst what already available? A few quick comments and then we'll move to next agenda.
Yeah, okay, very short, I think. I mean, ADR is nothing new. ADR has been used also for SEP portfolios in some cases. ETSI has cooperated with WIPO to create a set of rules because this is the challenge, and this is also the challenge for using ADR mechanisms. That is, of course, if you go through an ADR process after years of negotiating already, and then the only result is a further delay, so it is used for delaying further, then there is not an interest to do so. But if you say, well, we know from the outset we cannot agree between the parties, but we would accept a third-party arbitration to agree that, and the agreement is
no,
done
those are the part of those
sense.
agreements when they get entered into the agreements. So the arbitration clauses are the standard part of those agreements. So that is already available. In addition to that, if anything, Patrick.
No.
Sorry, if I missed any point, but yeah, Patrick, please. Yeah.
No, I've nothing actually to add there to Dirk. I think one of the complexities of ADR is indeed agreeing to the ADR in the first place. If that can be overcome, it's a solution perhaps. But
Dirk, sorry if I interrupted you. If you have a comment, then
no, fine.
Okay.
Thank you.
Thank you so much. I think we had a very nice discussion, and I think it was a great learning opportunity for me and for all. Now, before or without indulging into any summing up activity, I think everybody is so alert. So I move to the next agenda, and I hand over to Amreen to take the agenda forward from this place. So,
right, sir. Yes. Now we'll be having Shri A.K. Mittal give the closing remarks for the webinar. Sir, I'll invite you to please take the floor.
Yeah, thank you, Amreen, and I thank ASSOCHAM and NIPO to have invited me here. It was a real great pleasure to be here among the experts. And in fact, I was so much lost in the discussion. There was so much of learning on new things. So even I have been chair of the IPR committee of TSDSI for initial 4 years. And I have interactions with Dirk Willer on this aspect on some occasions also. So, and I can say that IPR policies are always changing environment. They are always developing, and there is always a scope to do something new. Of industry and the way the technology is actually growing and developing, and patents are growing at a fast pace. So the problems are also, or the issues to be addressed are also increasing. But I think I must congratulate Dr. Yashwant to have put, very right questions to highlight the issues and hear the views from the experts. Mr. Patrick and Mr. Dirk Willer, and both of them have gave a lot of insights into each of these issues which were raised by Dr. Yashwant. So very quickly to summarize the issues, there are too many notes which I have taken, but I will go through quickly because we are running late also. One of the issues was the very important foundational issues was significance of standards and the standardization patents. So this was very nicely explained by both the panelists, and the standards significance people know, and one of the major points in the case of telecommunication is interoperability across the globe, which drives these standards, and also the special issues with respect to the patents which this industry has compared to many other industries which deal with patents, and which amount of patents which they have. And the second point which was summarized and which is an agreement point right now is there is no legal definition of SEP, but the SDOs themselves define it as patents, without which you can't really practice that standard. So, so being that basis, the significance is that the incentive to the owner of the patent is or inventor is that they can sell these patents and have a commercial value of that, so that there's enough incentive, and also that the technology reaches to the end user finally. Then is on SEP licensing, the FRAND and SEP, they go together. Almost every SDO has, a FRAND, or some people remove F from that, they say RAND, but it probably hardly matters. Ultimately, when they negotiate, fairness comes in picture by the law of the land. Otherwise, if you have to be fair, you have to follow the competition law, you have to follow the contractual law. And this point of contractual law, patent law, and competition law has come out number of times during the discussion, that patent negotiation and a legal challenge to that cannot be settled without all the three. So on one side, there is a contract between the SDO and the patent holder, and on another side between the licensee and the patent holder. So contract and competition, and there are too many complications. There is no time to actually dwell on that. There are too many issues on when antitrust applies, when contractual law applies, and when only innovation value applies, and how to handle them. There are a number of court cases. Some of the court cases were cited at the end. I am coming to that. Then it also mentioned that the SEP licensing, the court cases, courts have actually provided more clarity. And the one major clarity which has come over a period of time is that the portfolio licensing, which is a set of patents which may contain SEPs and non-SEPs, and which is on global level, because the supplier of the licensee normally has a global market, and the organization which has developed the patent is also a global organization selling to the licensees all over the world. So the portfolio licenses have a global nature, and this gives an advantage that when they have an agreement on portfolio licensing basis, they become global, and they need not run around the whole world to sue the licensee. So, so there is a so this is the advantage, but there are issues. Their patents might have expired, or they may not be applicable anymore, etc., etc. So this also is part of negotiation. Then we discussed the territorial jurisdiction again. Otherwise, fundamentally, there is a territorial jurisdiction in the sense that unless the patent has been granted in a jurisdiction, there is nothing. You can't sue a person who is using the patent. But the portfolio licensing obviates the need of that. But even then, there may be implementers who are local, and the jurisdiction issue may arise, and they do arise sometimes. Then comes the major issue of holdout, which was discussed at length. And it is the case where the potential licensee has infringed or has started using the patent without permission and without paying the commercial value. And then when negotiations start, they are unwilling, not on the face, by their behavior, that they delay for various reasons. For example, one example was given that they will bring people who are non-technical, or they will concentrate only on technical issues, don't come to the commercial, or have a behavior. So all that normally is decided in the court if there is a delay. But this holdout also brings out a fact that this is the reason why the SDO policies say that you will have a good faith negotiation. Both parties should have a good faith negotiation. Otherwise, it is difficult to SDOs to describe that how the implementer and how the patentee should actually behave and how should they negotiate, because it's a business decision and enter into the should not enter into the commercial part of this activity. SDOs are bodies, technical bodies, who develop standards and provide a platform for exchange of information, declaration of IPRs, and enable the members and the users that the IPRs are made available for the common good of the public. Then the question came over, so holdout is an issue which ultimately is settled in the court if the good faith negotiation. Then the issue of US Department of Justice letter to IEEE on IPR policy. So there was some letter issued in 2015, which probably was interpreted as the IEEE policy, which has the methods of FRAND licensing and the preferred ways of calculating the royalty, etc., and some other aspects, including injunctive relief and other things, which was revised in 2019, as Patrick also mentioned, and was also read by Mr. Dirk, that there were issues, and it was finally DOJ has said that injunctive relief has to be on the table. Otherwise, it gives a incentive to the implementer, to actually delay or do a holdout. So it should be on the table, but should not be used unless it is established that good faith negotiation is not happening. So it should be on the table. And there are
right, sir. I'm so sorry to cut you, sir. It's already 3:30. I just thought I'll let you know about it. Yes.
Okay. So in the closing remarks, there were other issues which were discussed, but finally, the things which have been clarified in court cases, their development, about the injunctive reliefs, about SEP licensing, good faith negotiations, declaration of license, IPRs to the SDOs, etc. All that have been discussed in detail, and our panelists and our moderators have provided a lot of clarity on these aspects. Thank you very much.
Great. Thank you so much, sir. And on behalf of NIPO and ASSOCHAM, I would like to thank our guest of honor, Mr. A.K. Mittal, our moderator, Dr. Yashwant Panwar, and our distinguished panelists, Mr. Dirk Willer, Mr. Patrick Hopkins, as well as President NIPO, Professor T.C. James, and of course, our very vibrant audience for this highly informative and engaging webinar. I would also like to thank ASSOCHAM and the cooperation extended by Mr. Nahid Alam and Mr. Yashpal. NIPO will continue to create awareness in such pertinent issues, and we look forward to your participation and kind support in our endeavor to make India a global hub of intellectual property. Thank you so much. Thank you.
Thank you. Thank you, everybody.
Thank you, everybody. Have a great day. Thank you. Bye-bye.
Bye-bye.